And thank you everybody for participating. I'm going to try to share my screen now. And while I'm doing that, I will tell you why I'm involved here. I've been involved with CXC since the very beginning. 5 years ago, my son is an editorial cartoonist, most recently the editorial cartoonist for the Columbus Dispatch. And unfortunately, editorial cartooning is a art form that is going the way of the dinosaur, I'm afraid. Newspapers are not willing to pay for that. But we've managed to raise Nate so he's got good values and he knows how to draw. And he's actually making a living for himself as a creative, and we're thrilled with that. I've been advising CXC from the beginning. I'm also on the board of directors for the Columbus Museum of Art and Columbus College of Art and Design. And so I sort of know what artists are concerned about. So I wanted to talk a little bit today about issues that might be of concern for you all. But at the same time, I want to make sure that you know that this is not legal advice, and I'm happy to talk to you about legal advice, but check in with your lawyer if you're looking for specific legal advice. And I also just wanted to sort of preface everything here to say that this is the first CXC that we haven't had Tom Spurgeon with us. And so I just want to, for a moment, remember that this wouldn't have been possible without the good efforts of Tom and his friends. What I'm going to talk about today are different kinds of business that you might want to consider, and then some advice on good business practices. And I'll conclude with some thoughts about intellectual property and how to appropriately protect IP, steps that you might want to take to make sure that you maintain the copyright of your work. With respect to business, unless you've formed a separate business entity, you are a sole proprietorship. You are the owner of your business. You don't have to make any sort of filing to be a sole proprietor, and that's great. The key on that is that you generate profits and have expenses in your personal name, and you probably identify those on Schedule C of your income tax return, and hopefully you're making a profit. But if you want to go into business with someone else, the most common form is a partnership, and there's different kinds of partnerships. The traditional general partnership means that both partners are liable for the acts of their co-partner. They also have equal management rights. But many years ago, state legislatures came up with an animal called a limited partnership, which allows one person to be the one responsible for management of the partnership. That would be called the general partner. And then another one or more partners would be the limited partners, who have a share in the partnership profits and maybe some limited voting rights. But in general, they do not get to control management. Limited partnership is good if you've got sort of passive investors. If you've got somebody who is in the background, someone who's like providing capital for you, who's sort of providing background funds to keep you going, they can be a limited partner, and you can create a limited partnership which would allow them to share in the profits of the venture and maybe a certain limited degree of control, but they don't have any of the exposure that you would have as a general partner. To create a limited partnership, though, you have to make a filing with your state Secretary of State. General partnerships arise just automatically, but a limited partnership, in order to get its limited liability, has to first make a filing with the Secretary of State. In Ohio and in most states, a filing is a very simple process. It's a one-page form, and basically, I'm not looking at you guys while I'm talking, but I will try to do a better job of that. The limited partnership requires you to make this filing with a nominal fee. In Ohio, it's $99, and the entity has to have what's called a registered agent or a statutory agent, someone who lives within your state, which would typically be you, who would be the party who receives official notices, court summons, tax notices, things like that. Once you file a limited partnership, there's no ongoing returns you have to file because a partnership is deemed a flow-through entity, so they don't tax the partnership separately as an entity. It's whatever results from the business are reported on your personal income tax return. And unlike sole proprietors, where you would report your business on Schedule C, for a limited partnership, you would report that on Schedule E if you're doing your own taxes. There is an entity called a limited liability limited partnership, which is formed the same way as a limited partnership, but what it does is it gives some limited liability to the general partner manager. So you might want to consider an LLLP as your vehicle of choice if you and someone else are in business together. The term joint venture is not a legal term. It simply means a partnership for a specific purpose. Typically, if you're going to have an ongoing business that's doing a variety of things, it wouldn't be a joint venture because it's going to have multiple purposes, multiple activities. But if you have a very specific project, it could be a joint venture, and it could take a form of either a general or a limited partnership. A limited liability company might be an even better form of business for you, because an LLC means that all the entity owners have limited liability. That would mean the person who's managing the thing, as well as more passive investors, sugar daddies, or whatever they may be. LLC, just like a limited partnership, has to be filed with the Secretary of State first. Again, it's a relatively cheap filing. It's $99. You can actually do it online, and you can do it yourself. You don't necessarily need a lawyer or an accountant to do it for you. It does require that you appoint somebody as the statutory agent, which can be yourself, and that person would get governmental notices. But the LLC, once it's filed, is a separate entity, and we'll talk about what that means in a moment. The LLC allows you and anybody else you're in business with to take whatever actions you need without fear that your personal assets would be at risk. The last form of business that I want to talk about is the corporation. There are two tax types of corporation. An S corporation is a regular corporation, but the results of the corporation are reported on your personal income tax return, so there's no separate corporate tax. And the C corporation is the opposite. It has a separate tax identity, and it is taxed as a separate entity. Now, why would it matter? It depends on tax rates, really. The standard income tax rates for corporations is 21% now. Depending on the election, that could well go up. 21% income tax rate may be higher or lower than the tax rate that you are personally paying. The highest personal income tax rate right now is 39%, but it goes down to 10% or lower depending on the amount of revenue you got. So you got to compare your personal income tax rate against the corporate rate to decide whether it's worth your while to be a corporation or not. What's the difference between a corporation and a limited liability company? Limited liability company gives you a lot of flexibility. You can divide up management the way you want. You can divide up how you share the profits the way you want. With a corporation, it's strictly on a per share basis. So with a corporation, which most everybody's familiar with, you have shareholders who elect a board of directors. The board of directors elect officers. And everybody's vote is proportional to the number of shares they have in the corporation. That's just basic democracy there. But you might have situations where you want to have Joe Blow having sort of veto rights over one thing, or Sally Smith having a preferential return on profits. And an LLC might give you more flexibility on things like that. So in general, I'd say if you were looking for liability protection, either a limited partnership or a limited liability company or a corporation is the way you want to go. But you don't necessarily need that. If you're bringing in another person to be a co-owner of the business, for sure you need one of those partners. A sole proprietorship is necessarily an individual. So when you're bringing in a partner, that you need to think about one of these other things. One thing to bear in mind, though, too, you can also have a single member limited liability company. If you want to have some limited liability to protect your personal assets from business assets, the LLC or a corporation might be the way to go on that. Next sort of way to protect about your personal assets is to make sure you got a really good insurance program. And there's a few people in life that it's always good to know. It's always good to know a doctor in case you have a problem. It's always good to know a bail bondsman in case you get, picked up for whatever. It's always good to know an insurance agent. And it's important that the insurance agent knows what your business is. Most people will probably have a personal policy which would cover their home or their apartment and their personal property, their furniture and dishes and things like that. And they should also have a liability policy that goes with that homeowner's policy, and that will cover your automobile. Of course, by law, we have to have auto insurance in order to be able to get a license plate. But a liability policy also includes coverage against general liability. That is, when the third party sues you for your having done something that did damage to that third party. Like, let's say you knocked over something they had, or you may have defamed them, or you may have accidentally damaged their house or something like that. That's what a liability insurance policy covers. On top of that, you might have umbrella coverage, which means that the liability policy usually has a limit, and for a lot of people that limit may be $500,000 or maybe $1 million or maybe even $5 million, depending on how much premium they want to pay. But that's the limit of coverage, and some people want to have extra coverage on top of that, and that's what umbrella coverage would be. If you're a sole proprietor, then you need to have liability insurance on top of that. However, insurance companies do everything they can to try to avoid paying out on claims. And so sometimes in their policies, they'll say, we will cover you except for business activities. And this is where I think it's important that you know your agent, because you got to talk over your agent what you're doing, what exposure you think you have, and what kind of coverage you want to have. A business policy will cover the gap where your personal policy may not apply. So a business policy will cover the personal property that the business has or the real estate the business has, and it'll also have a commercial general liability component. So it's important to maintain that insurance. The cost of insurance, whatever premiums there are deductible against whatever income you have from your business. On top of your insurance program, it's important to maintain appropriate protection for your family and your heirs. And I always recommend that it's important to have a will and to maybe have additional estate planning documents depending on your needs. And here's where you really do want to consult a lawyer on this. It's not something you should be doing yourself, particularly if you're an artist, and particularly if you have intellectual property, work that is original, that you want to protect and you want to profit from. Your heirs can also have those same rights if something happens to you. The copyright law provides that if you were to die today, the copyright that you have in your artistic works would last for another 70 years from your death, and that passes to your heirs. And a will specify that, or at least it'll include a residuary clause that says all the rest of your property will pass to whomever your heirs might be. One of the good reasons to have a will is that there's a little phrase in a will that says, I appoint X to serve as my executor without bond. And the term without bond means that if you have an estate, the executor does not have to buy a surety bond to protect himself against any heirs or claims that heirs may bring. And a bond is a fairly significant expense, which is unnecessary if in the will itself you say, I waive bond for my executor. The executor is the person who will be responsible for wrapping up your affairs, paying off your debts, and then distributing your assets to your heirs. Depending on who your heirs are, you might want to have a trust agreement as part of that estate plan. A trust would set up a separate person to serve as trustee to hold the legal title to assets and manage those for the benefit of your heirs. This is particularly useful if you are doing it before these heirs are of an adult age, or if they are people who you think need to have particular care long after you're gone. So the trustee should be someone whom you trust, who has the ability to manage your assets and your estate after you're gone. A power of attorney would be used for someone who might not be able to take care of the affairs themselves directly. So for instance, if you were, if you had a concussion and something needed to get done, a power of attorney could be granted to someone who has the ability to act on your behalf. If you were not of sound mind and you were like in a nursing home or something like that, the person who is your attorney in fact under that power of attorney could take actions for you and pay your bills for you and take steps to manage your affairs when you yourself personally couldn't take care of it. Most states also have a healthcare declaration or a living will, and these are standardized documents that allow certain people like family members or your spouse or someone you trust to make medical decisions for you in circumstances where you can't take those decisions yourself. And a living will would be an instrument that expresses your desires as to whether or not you want extraordinary measures taken to keep you alive in case something happens. All of that is part of an overall asset protection strategy that you ought to have. So the first bit of advice I'd make is that consider having an entity that will allow you to have limited liability for actions that you take in your business. And as part of that, if you do have a separate entity, make sure that you maintain the formalities of that. And by that I mean that if you've got a LLC or corporation, make sure you have annual meetings and write those down. You have minutes of those annual meetings. Make sure that you elect directors and officers on a regular basis, and that if you're going to be one of those directors and officers, make sure that when you sign documents in the business name, that you sign it in your capacity as an officer. What you want to do is prevent creditors from thinking that you are personally on the hook for something. You want to demonstrate to those creditors that you are a representative of the entity that has the limited liability, so that if they've got any claims against you arising from contracts that you may sign, their only recourse is against the entity itself. Then that entity itself should have insurance, just like you personally ought to have insurance. Another important strategy in this is you want to keep your business accounts separate from your personal accounts. A business, especially if it's got more than one owner, will have a separate tax identification number. Your Social Security number is your personal tax ID number. A business has its own form of tax ID, which is a Federal Employer Identification Number, FEIN. And the business would have its bank accounts and other investment accounts linked to its FEIN, rather than to your social security number. Then another thing that you should bear in mind is when you have personal assets and business assets, not only are they in separate accounts like at a bank, but also some personal assets don't necessarily belong to the business. So if you've got furniture and fixtures and art supplies and other things that you're using in the business, buy them in the business name. Use the business credit card for those assets so that they are not confused with your personal assets. Having separate assets, especially assets that can be titled like cars or boats or real estate, have that in a separate name rather than your personal name. We've already talked about estate planning as an important component of protecting your personal assets. And then keeping good records is really critical because most people, when they sort of mix up their personal activities with their business activities, sort of figure, well, I'll worry about this at tax time, and they don't really try to keep a record of where did the money come from, where did it go, if you got a loan from somebody, where did this loan come from, whether this was money that came from a particular work or a different work. The key is be meticulous in your record keeping. Also, make sure you're not obliging yourself to stand for someone else. You don't want to guarantee somebody else's promise if you can avoid it. A lot of times creditors may ask you to have a guarantor. That's okay if you've got someone who's willing to guarantee your obligations, but you don't necessarily, if you can avoid it, want to stand behind someone else, especially if you don't have any degree of control over that person that you're serving as a guarantor for. There's certain activities that you need to have a license for. In art, fortunately, they're not licensing things, but if you were selling art, you might need a vendor's license. And in Ohio, for instance, we get a vendor's license from the county auditor's office. And what that does is it authorizes you, when you sell a work, to collect sales tax from your buyer. And then it obligates you to remit that sales tax to the county treasurer. And if you don't, the state's going to come after you because they will assume that once you've started collecting sales tax, you are being properly allocating it to the state, and they will hold you personally responsible for tax that you collect from your customers that you don't pay into the state. Once you've started to file sales tax returns, make sure that you don't go several months without filing others, even if there are nothing to report on those returns. The state has computers now, and they just track, and if it turns out that someone doesn't file a sales tax return when they're supposed to, the state computer will flag that, and all of a sudden they'll sort of assume that you had a certain level of sales, and they will then say, oh, you didn't file a return, there's a late return penalty, and there is interest running on what we will assume were the level of sales you had. And all of a sudden you get hit with a penalty for taxes on sales that were never made at all. So once you start filing sales tax returns, make sure you keep doing that. Now, it's easier to do nowadays, so we can do it online, and you don't have to send in paper returns that could get lost in the mail. But make sure that if you are filing sales tax returns, or for that matter, really any kind of tax return, that you continue to do so. And if you're going to stop, the very last return you file should be marked prominently on the front, final return, so that you're making it clear to the state agencies that this is the last time I'm going to be reporting to you, and you can close out the account on me. Now, let's talk a little bit about some of the financing elements that you might need as you're going forward. You might need extra capital to expand your business, or maybe you're running out of cash, and during this time of COVID, that's what people are doing, running out of cash. There's two basic ways to raise money, and one is through sales of equity in the business, and the other is through incurring debt. A sole proprietor can't sell equity because the sole proprietor has a single owner. But for a limited partnership, you can sell a partnership interest. For a limited liability company, you can sell units in the LLC. For a corporation, you can sell shares of a corporation. And those ownership interests can be common shares, meaning everybody shares equally, or you could sell like a preferred interest where someone gets paid off before someone else gets paid off, or you can have different classes of ownership. And the differences between those classes can be set forth in the governing instruments for the different entity. You can also, if someone is helping you out and you want to give them the opportunity to maybe get get in on the ground floor, you can give them options to purchase an equity interest in the future. This is the way an awful lot of high-tech companies have developed through the years. They weren't able to pay cash to the people who were working in Silicon Valley, so a lot of these workers would get maybe nominal amounts of salary, but they would get paid with stock options, which allowed them to buy shares of the company at a really low price. And so that if the business ever did go public or have a higher price, or they might have been bought out by venture capitalists, the people who had stock options could exercise their options, and then suddenly they would have something that's worth a lot of money, even though they only paid a little bit of money for the option itself. So options are a way to maybe incentivize people who are working with you. Debt financing is basically evidenced by a promissory note. And it's important to document the note so that it's in writing, so it's not just your word against somebody else. The document, which is a fairly simple form, it's an IOU, but it should specify who the borrower is. It's either you personally or your business. It ought to identify who the lender is, who's the person who's going to get paid back, the exact amount that was loaned, what interest rate is payable, and that can be any rate you want, but under the federal tax laws, it ought to be at least or no less than the applicable federal rate, the AFR, and that is right now in this time of a really low interest, a really low applicable federal rate. You can have an arm's length loan between a borrower and a lender, and the applicable federal rate can be as low as like 0.3% or even more than that. It depends on how long the obligation is, but the interest rate should at least be an arm's length interest rate so that the government will honor and recognize that promissory note as being a legitimate debt obligation. The promissory note also probably ought to specify when payments are going to be made on that loan, whether it's like due in installments, like certain dollar every month, or maybe annually, or maybe it's all just due at the end with interest accruing till the end. And there ought to be a clear stated maturity date for when that debt is payable. Most promissory notes, IOUs, can be unsecured, but they're for banks and most formal lenders, they're going to want to have some sort of collateral. A promissory note just evidences the debt, but the collateral is what secures your promise to pay that debt. And collateral can be in the form of a mortgage on real estate or a security interest in personal property. And it's up to the lender to decide what they want to do in terms of collateral. With respect to debt, just like you need to have an insurance agent and a good doctor, you ought to have a good banker, someone with whom you can develop a relationship. Many of you may have heard that when the CARES Act was passed, sole proprietors could take out a PPP loan from banks. That was something that was never possible before. And the Paycheck Protection Program was available through the Small Business Administration as a way to keep a certain amount of income, payroll income, flowing during the pandemic. The PPP program has been suspended, and maybe if Congress gets their act together, CARES 2 will have an additional PPP program. What we have heard from Washington lately is that If they do have more PPP funding, it'll be for small businesses, and it'll be from especially minority businesses and businesses in non-traditional places. Won't be for these great big well-heeled companies, many of which got PPP loans during the first go around in the spring. The program is administered by the Small Business Administration. And right now, unfortunately, the PPP program's got a lot of administrative issues and questions about it. We're hoping Congress will clear some of those up if they ever act on a CARES Act 2 program, which will probably, if it happens, happen after the election. The SBA has some other programs too, though. There are small business loans, the 7A program you may have heard of. The 8A program is for minority loans. There's a program called the 504 loan program, which is for real estate loans for small business. And then there's also disaster relief available through the SBA. If you had a tornado damage, hurricane damage, forest fire damage, things like that, the economic injury loss loan program, EIDL program, is available through the SBA to provide some emergency help to you. There are also local programs available. State and cities and counties have financing available for small business. And in almost all of these cases that we're talking about here, the lender's going to want some sort of collateral. They may want you as an owner of the business to personally guarantee the loan, but they're also going to definitely want to have a mortgage if you've got real estate. They might want to take a security interest in your personal property or your intellectual property. That's what a lender requires as sort of the price that you got to pay in order to get that loan. Couple of quick notes on basic contract law. You got to get a contract in writing. Most of the time, party is going to give you a contract, and a lot of times it may be on a take it or leave it basis, but everything is negotiable. So when someone gives you a contract, feel free to try to negotiate any element of it you can. Basically, when they are presenting you with a written contract, they're making an offer, and it's up to you to accept or to counteroffer. And once you've accepted the offer, then you've got a contract, and then there's some consideration that makes that contract enforceable. Consideration being money that's flowing from one side to the other, or in the case of a mutual contract, somebody's willing to pay you for a work of art that you are giving them. That is a bilateral contract. And so once that's been done, then you've got a contract, assuming you have the capacity to contract, meaning you're an adult, you're not under any disability. So in general, remember the contracts are negotiable, but you absolutely have to put it in writing. Now, let's cover a few intellectual property issues because I don't want to talk too much, and I want to leave some time for questions. The important thing to remember about intellectual property is that there are different kinds. Everybody's sort of familiar with copyrights, patents, trademarks, trade secrets, trade dress, publicity rights, unfair competition. Those are all intellectual properties that are protected under the law. The idea of a copyright is to encourage and reward creative expression. It's for any work of authorship. Patents apply to original, new, or useful innovations. And I'm not going to cover them in this program because we're basically talking about works of art. I will talk a little bit about trademarks, though, because trademarks are something that a person can use to distinguish their product or service from someone else's. So let's look a little bit more about what that might mean. I got an example here of a Coke can, which is basically multiple examples of intellectual property all at once. There are utility patents in the fact that there are the way that the can is designed. Also, the beverage within can have a utility patent. As it turns out, Coke has never patented their secret formula, but it could. There's a design form patent in the way that the can is set up, including the way the barcoding is. There's a copyright you can have on the way the can has its artwork presented. There is the famous Coke trademark. The trade secret applies to what's inside the can. You can have overlapping protection on all these things. And so really this Coke can is in a way just a little microcosm of the different ways you can protect intellectual property. For copyrights, the basic requirements are it's got to be an original work, but it can be anything. It can be a tangible drawing, it can be a book or a novel, it can be music, it can be software. You can have copyright in wallpaper, you can have copyrights in all sorts of things, including like computer designs, things that you wouldn't have expected. You can't copyright an idea per se, but you can copyright the way that idea is expressed. So the copyright for something of like happiness, that's not copyrightable, but a work about happiness is in fact original and it can be copyrighted. There are two ways to get protection for a copyright. There's common law copyright, which means as soon as you generate an original work, it's protected and it's yours. And if you want to have an extra level of protection, you register that copyright with the United States Patent and Trademark Office in Washington. There's a little filing fee with that, but what that federal registration does is it allows you to get extra damages in case somebody infringes your copyright. With the trademark, the key is you're the first one to use that particular mark, and it identifies your specific goods or services. It can't be sort of generic. So everybody is familiar with the Coke trademark or the Honda trademark or the swoosh for Nike. Those are all trademarks because they have a secondary meaning. Not only are they a symbol, but they mean something else to the average viewer. The source of the rights in intellectual property, in the case of copyright, is as soon as you create that tangible means of expression. And as I said, you can get the extra protection through registration, and that gives you special damages in case somebody tries to steal your copyright. With a trademark, before you register it, you can use a trademark, but if you're going to claim exclusive rights to that, I would recommend you put that little TM up there at the top to let people know that you're claiming rights to that mark. And once you make your registration with the U.S. Patent and Trademark Office, you're entitled to get that little R in a circle to tell the world that you have exclusive rights to the trademark. A copyright has a life of 70 years plus the life of the author. But if it is multiple parties, then it's going to be the shorter of 95 years from publication or 120 years from creation. Thing that you have to remember about copyrights is that the law changes. Congress can change it at any time. Other countries have different laws about copyright, but a copyright in the old days was less than 70 years, and only at the behest of the Disney company did it get to be extended to 70 years. A trademark is as valid as long as you continuously use that trademark. The copyright will give you exclusive rights to make copies of the work, to do derivative works, to present copies to the public, to perform something publicly like a dance, to display artwork publicly, or to perform, by radio, television, whatever. There are fair use exceptions, which we'll cover here in a moment. A trademark, though, will give you exclusive rights to prevent others from using confusingly similar marks. And one of the examples I always give was when I first started as a lawyer, our client was Wendy's. And there was a outfit down in Nashville, Tennessee called Judy's. And they used exactly the same logo, the same typeface, same font. They had the same kind of store design and everything. And Wendy's was able to stop Judy's from violating their trademark. The copyright is owned by the author of the work, but there are exceptions. The author can transfer ownership of the work by written agreement. That would be like an assignment. If you are an employer of someone who produces an original work of art, you can, as the employer, own that because you have an employment relationship. That would be what's called the work for hire doctrine. But that's in an employee-employer situation. If you're an independent contractor, meaning you're not employed by that party that's hired you to do a work of art, an independent contractor does not have the work for hire doctrine. So the independent contractor owns the copyright of their work. And so if you are hiring an independent contractor to do artwork for you, you want to have a contract that says, I, the hirer, own the copyright on the work. You have to specify what that is. Trademark is owned by the entity that first uses the mark in connection with goods and services, and it too can be assigned or licensed by the owner. Assignment would transfer all rights. It can be made at any time. It can be in writing. For a trademark, you also not only assign the rights to the mark, but also the goodwill associated with the mark. An assignment means that you are actually transferring it and you're not keeping anything. A license means where you're transferring it for a limited purpose. And so you may be licensing it for a term of years or for a certain use or for maybe a certain kind of medium. And with a license, you get to charge royalties. So you may get some money depending on a per use basis, or you could set the formula any way you want. But the distinction between assignment and license is that assignment transfers everything away. A license, you're retaining the base ownership of the intellectual property. There's various ways that infringement can happen. There'd be claims sometimes that you might be infringing somebody's copyright. So there's various defenses you could put up if you're ever challenged. The first is that you could say, well, the work that you say I'm infringing is in the public domain. It's already been publicized and I'm not responsible for that. Or you could defend yourself by saying, well, the work that I'm allegedly infringing isn't very original in the first place, so you don't have any rights in it. Or you could say, well, I'm not infringing it because I got a license to use it. Or you could say, well, you've brought this action more than 3 years after you knew or should have known that this infringement took place, and so I'm outside the statute of limitations and you got no claim against me. Or you could argue that, well, you know, maybe I'm sort of close to what this copyrighted work is, but not substantially similar, so that's a defense. Or you could also raise a de minimis defense saying, hey, look, I'm only using this little tiny piece of the work and I'm not using the entire work and I'm not passing it off as myself. There's also what's called the fair use doctrine, and that means that you can use somebody else's work for a limited purpose, like if you were using it for criticism or commentary, or you're reporting it as a news item, or you're teaching, or you're writing an article about it, or you're researching something. In the fair use doctrine, a court will look at 4 basic issues: whether the purpose and character of the use is permitted. If it's commercial use, they're going to be thinking, well, maybe that is an infringement. But if you're using it for non-commercial use, maybe you're not. Maybe it is a fair use. It'll depend on the nature of the work. It'll depend on the significance of what you're using compared to the entire work, and the effects on the overall market for that work. Then you can use, under the fair use doctrine, work where you've transformed it into something else. And the best example of that is where Andy Warhol did the Campbell soup can, or the photo of Marilyn Monroe, or there's actually a more recent case about the Andy Warhol use of a photo of Prince. And in every one of those cases, Warhol had a fair use defense. That is, he was using the Campbell soup can, but transforming it into a different character, or he took the photo of Prince and transformed it based on color and the way that the lighting was done. It will be really interesting as the future develops on how social media will impact the fair use doctrine, because people are going to be violating copyrights left and right, and we'll see whether or not there's litigation that develops through what is an appropriate use of a copyrighted work within the framework of a Facebook posting or an Instagram posting. I wanted to identify one interesting case that recently, remember the movie Inside Out, where the characters each personified a particular emotion. There was a company that sued Pixar saying that their characters called moodsters were really the origination of the characters in Inside Out. And the court found in favor of Pixar because they said the moodsters characters were not trademarked, they weren't copyrighted properly. And so what that proves is if you've got an idea that you think somebody later on could potentially infringe, consider copywriting as much as you can and trademarking as much as you can. Since I'm running out of time, I just want to talk a little bit about basic strategy, and this is maybe the most important thing we're going to talk about today. Copyright any original work you have. The simple way to do that is just say copyright 2020 and your name, or the little C symbol with your name, and the year is not critical, but it's always helpful because it helps you document when you first use this. Putting those words into your work are absolutely critical to a claim of copyright. It gives you a common law copyright for sure, and then that would be the basis for a registration that you would make with the US Patent and Trademark Office. Whenever you got an idea or a work that you think is commercially valuable, talk to an IP attorney as soon as possible because they can help you get the protection you might need. The laws in Canada and Mexico and the EU and Japan are all different than they are in the United States. So if you've got a work that you think might have a market way beyond the United States, for sure consult an IP attorney. If you're going to be using any works from others, try to get their permission first. Warhol did not necessarily get the permission from the person who photographed Marilyn Monroe or the person who photographed Prince before using those photographs in manipulative ways. He would have avoided for himself and his estate a lot of hassle if he had tried to get permission first. Also, if you're going to sell works, it always helps if you can provide to the person who's buying the work a certificate of authenticity. It helps them establish provenance. One of the things that museums and galleries and other parties who are dealing in art always have a problem with is to have sort of a chain of ownership, and it's you as the author can help them and help yourself against people from misusing your work and other people's properties if you establish who you sold it to and what the actual original pieces of work are. For trademarks, get clearance, identify unregistered marks, check with your lawyers, especially if you're going to start using a product in interstate commerce. Identify your marks with the registration notice. Be careful, there are certain companies like Xerox and Cellophane and Kleenex that never properly policed their trademarks, that is, prevented others from using the term without giving credit to the original inventor. And so the term cellophane now is in the public domain. The cellophane company lost the exclusive right to use that. Kleenex and Xerox, you will see every so often advertisements in the Wall Street Journal and other papers to say the word Xerox is a registered trademark of Xerox Corporation. And they're doing that to police it so that nobody uses Xerox as a generic word for photocopying. Then I want to make sure that if you take nothing else away from this program at all, always claim your copyright, always document your licenses, use written agreements with your employees if they're doing work for you, written agreements with independent contractors, because you want to specify who owns the intellectual property that they are developing for you. I'm going to skip these intellectual property mistakes in the interest of time here, but anybody who wants to have a copy of this presentation, I'm happy to email it to you. Just drop us a line. So thank you for putting up with 55 minutes of talking here, and I'm happy to answer any questions that you might have. And Jersey, if you've got any questions, let me know.
Thank you, Jack. That was awesome. And we got a lot of positive feedback in the chat while this is happening. There's some very appreciative artists that were watching live. And we did get a lot of questions. So if you have a few more minutes to spend with us,
Absolutely.
all right. So Mandy asks, if I have two businesses, one product-based and one service-based, do I need two LLCs or will one suffice?
I think one will probably be enough. I don't think it's necessary to have multiple entities. And, there's a lot of record keeping and expenses associated with having a separate business. So you can have multiple lines of business within the same entity.
Okay, cool. Because I only have one sole proprietorship and I do lots of different kinds of things, but they're all related to comics, and that's how I've been justifying it to myself. So if you run your own business out of your home, do you still need separate business insurance?
Probably. And this is why I think it's a good idea to talk to your insurance agent about that, because your homeowner's policy might not protect business assets. And if your business assets are primarily intellectual property, they're in your head anyway. But if you've got like tangible work, if you've got a printing press, a lithograph, or I don't know what the equipment's called, that kind of work might not be covered in a typical homeowner's policy. So I'd suggest you just talk to your agent. They're getting a nice premium for giving you this insurance, and he's getting a commission on this premium. So your insurance agent owes you the time of day to give you some advice on what's a good insurance program to have.
Oh, that's good. That's good to know. All right, so we've got more. So question, this is from Wes. I'm a sole proprietor and I want to set up a living will. I have an IP that I want to give to my heirs. Can I still do that even though I'm not an LLC or corporation? If so, what info do I give to my lawyer to show that this is an asset?
I would say tell your lawyer the works that you want your heirs to have, and it could be something generic like all artwork that I've produced, it's quite all right to specify that in a will or in a document where you're transferring the rights to those heirs. But I'd say for sure let your estate planner know what that work is, and they then can structure it by having either a separate clause within the will, or it would be included within the residuary clause, which is the paragraph in a will that says all the residue of my estate goes to X, my heirs, or whoever that may be.
That's great. Okay, so this is an interesting one, because this is sort of asking like some more abstract ideas that would be invisible to a lot of us artists who don't think about legal and business strategy as much as maybe we should. Is maybe not directly related, but what do you recommend an artist to look for in a lawyer when looking for help with IP infringement, etc.? Like, so Netflix comes calling, or somebody has stolen my work. Is there any like sort of like gut check that you could recommend in talking with a lawyer?
Well, I don't know that's any different than general advice about what to look for in a lawyer. I think you got to look for somebody who speaks your language, who understands what you do and what ideas you have, so they will be as knowledgeable as possible about what it is you're trying to accomplish. There are, within the business, most people will call themselves intellectual property lawyers, but the patent lawyers are really different than the copyright and trademark lawyers. Patent lawyers are engineers, and I'm not casting aspersions, but engineers are a different mindset. They're a different kind of guy. And intellectual property lawyers who know more about trademarks and copyrights are going to be a little more art-oriented. I guess there's a tendency for intellectual property lawyers to be in boutique firms rather than great big ones. Now, I happen to be in a great big firm, and we've got a big IP section, but that's unusual. Most IP lawyers might be one or two or three lawyers in a little practice that oftentimes is more suburban in nature. But look for somebody who understands your business. You might want to like ask at an arts organization who on your board is an artist. I'm sorry, is a lawyer. So maybe board members who know how museums think or who know how art colleges or galleries think. I mean, go to a gallery and say, you know, who do you guys use as your lawyer? That might be one way to look for somebody good.
Oh, that's great. Yeah, recognizing that they're going to have more of a nuanced approach if they're already working with that constituency. Yeah. We have one. Well, we have two more. And this one is from Jason. It says, if I'm drawing a comic strip that is a legacy strip, and the creator's family owns the trademark on the name of the strip and characters, what rights do I have as the copyright holder of the individual art that I drew on the strip? I am an LLC.
That's a really good question, and it's a really complicated question, but it's not too difficult to answer, but I'll try.
Okay.
The original artwork that you draw, you own. So what's on the paper, you own. If you're doing it online, the file, the online file that you have created, you own. So that original piece of work is what you have copyrighted. And you're exactly right that the family really owns the trademarked characters. And those are, in a way, that's sort of like an idea that they own. It's those characters have secondary meaning. Those characters all have sort of like a history, a biography to them. And that's what the family of the heirs of the original artist own. What you own is the way you've taken those characters and expressed them in a panel, in a storyline. And so the story, the specific tangible expressions, all of those you own. And if you wanted to then do further derivative works, like if you wanted to do a book of compilation, chances are you would own that, but you'd probably want to get a license from the family to be able to use those characters in the compilation. If you wanted to do a cartoon, you try to negotiate with the studio to animate it. And again, I'd probably recommend trying to get a license from the family for the use of the characters in the animation, but the story and the way that they're being drawn, you would own. If you're gonna do a Netflix series, I would recommend that, again, you are getting a license from the original family to the use of the characters, but the rest of the stuff you own. And Netflix, unfortunately, when you do these deals with companies that are doing a different kind of medium, they're going to want to own as many of those rights as possible. And what I would always recommend is don't assign those rights to them, license them. So that way you're keeping the base ownership yourself, and you're not giving away the store to the company that happens to make a movie about it.
Gosh, Jack, thank you so much. This was an amazing presentation.